2020 tax year session. First and foremost, I must acknowledge. Hello, this is William O. Shields, Chief Deputy Commissioner of the Cook County Board of Review, and I'd like to welcome you all to the attorneys meeting for the 2020 tax year session. First and foremost, I must acknowledge the leadership of the Board of Review, which includes the commissioners, namely Commissioner Larry Rogers Jr., Commissioner Dan Patlack, Commissioner Cavernargi, as well as Roland Lara, First Assistant to Commissioner Cavernargi, Phil Penner, First Assistant to Commissioner Dan Patlack, and Demetria Burris, Chief of Staff for Commissioner Larry Rogers Jr. Also, I must acknowledge Chief Clerk Alan Emanuel and Secretary of the Board James Thompson. In addition, I must acknowledge the very, very hardworking employees of the Board of Review who, without their tremendous sacrifices and a level of commitment, a successful and timely completion of the 2019 session would have been impossible, particularly given the current pandemic and the huge adjustment that many of us have had to make in our daily lives. This year's agenda will include a discussion covering the requirements, procedures for the 2020 assessment appeal session. We also will highlight certain board rules and procedures. We also would like to discuss certain enhancements to our digital appeals processing system. We do have certain recommendations for best practices. Also on the agenda would be a discussion regarding our exemptions, where it was changed from 4 installments to 2. We'll discuss the unauthorized practice of law, and then we'll end up with detailing the towns that are included in Group 1 in the opening date.
As predicted, the board adjudicated yet another record number of appeals and pins for the 2019 session. Last year, the board processed 253,430 complaints, which is the equivalent of 466,080 pins, and was a 10% increase over the 2016 reassessment of the northern suburbs. Now, for the 2020 schedule, this includes the reassessment of the south suburbs. Now, consistent with what we've done in past years, in order to have a July 1st mailing, the board must complete its session by mid-May of 2021. Since the implementation of our digital appeals processing system 6 years ago, we more than welcome the input of all stakeholders, including practitioners as well as board analysts. Based on that feedback, we've implemented certain enhancements to gain certain efficiencies for the users of DAPS. A copy of this presentation will be available on the board's website. For the 2020 tax year session, I'd like to highlight certain procedures here at the Board of Review, which include uh, our data compilation subscription service, certain revisions of the board rules, um, intervention rules that were formerly called undervaluation rules, the mandatory historical summary form, the 2020 attorney authorization form, and our recommended best practices. Please note that for this year, that there are no material or substantial changes to our data compilation subscription service. That being said, I'd like to provide you an overview of our subscription service. One, it's a compilation of board assessment data in a spreadsheet format. It also is a single point access to his assessment result data within subscriber's DAPS account, which is accessible only via the portal. Now, please note that the board decision letter batch and the board decision letter data document types will be present and contain all results that are associated with their attorney code for a given group. After providing you all with the overview of our data compilation subscription service, now comes the good part. How much does it cost? So what I like to do is just give you a quick summary of the fee structure for the data subscription service. Essentially, it's based on the historical filing frequency over the last 3 years. Please note that it's solely within the discretion of the board to determine the subscriber's appropriate tier. Now, regarding the historical filing frequency, please note that the data is being updated to include last year's session, the 2019 session, and deleting the 2016 session. After this data is compiled and analyzed, the tier structure would be adjusted, which will be memorialized in the forthcoming 2020 data subscription agreement. Now, it's important to note that your data subscription service will be activated after the data subscription agreement is fully executed, and this is the important part, the annual subscription fee is paid to the board. Benefits of the data subscription service include the electronic spreadsheet, one-click access, improved efficiencies, improved client relationships, and positive stakeholder feedback. Based on feedback from the practitioners and related support staff, the board has added a certain feature to the data compilation subscription service, which is the bulk filing utility. Benefits of the bulk filing utility include the streamlined filing process and improved labor cost efficiencies, validation of subscription users, provide subscription users the ability to bulk file complaints, as well as the ability to bulk upload supportive evidence. It allows subscription users to verify the progress of board receipt of complaints and supportive evidence. Provides subscription users a summary of the results for the complaints filed. Minimize manual entry errors for users. The application will not impact the functionality of the portal. In addition, the bulk filing utility will include certain reporting features such as upload confirmations, duplicate alerts, township status. Also, I must note that the bulk filing utility is a universal web service application outside of DAPS. Now I'd like to highlight certain revisions of board's rules and procedures, and I'd like to start with Board Rule 3, which states that failure to follow any rule may in itself be grounds for denial of any relief. Board Rule 12 was revised to in reaction to the current global pandemic, and particularly out of the health and safety concerns for not only taxpayers, but also the practitioners and board employees. The revision states that it's within the exclusive discretion of the board to determine the manner in which hearings are to be held. Should the board determine there is good cause to conduct hearings via non-in-person means, the board will communicate these procedures to appellants and/or their counsel, as well as provide notice to the public via the board's website. Board Rule 13 was revised to address the issue of the attempts to submit evidence after the submission deadline has passed. Particularly, there's no need for any appellant or their attorney to present any valuation evidence at a hearing, as the evidence submission deadline would have already passed. And we like to highlight that after passing of the evidence submission deadline, this evidence is not to be submitted by contacting the clerk's office. Late evidence will only be considered at re-review. Board Rule 14 is very important, and that's why we elected to put it in all caps to emphasize the importance of this rule. Particularly, all parties must file their documents no later than the period set by the board following the closing of the township for both desk review and hearing files. For properties other than residential properties, all parties must submit a brief as well as a complete historical summary form. This historical summary form takes the place of the former hotel and non-hotel summary form. The brief shall include a color photo of the front of the subject taken within the previous 12 months, and that accurately shows the condition of the property as of the lien date. This historical summary form must be completed in its entirety. The existence of any transfers or appraisals must be disclosed. If the appellant believes any value listed on the historical summary form is not indicative of fair market value, that should be addressed in the brief. Now, with Board Rule 27, this is the review rule. This process is analogous to a motion to reconsider in circuit court. A review is not the place to raise a new legal theory or factual argument. As a result, legal theories and factual arguments not previously made are subject to waiver. Now, because the review process is not to be employed as a substitute for otherwise timely submission of documents required by the board, the submission of an entire set of documents in the first instance at review will be considered in the discretion of the board only upon the showing of good cause. During the 2019 session, the board adjudicated over 200 complaints filed by taxing districts, but unlike in past years where the taxing districts were attempting to raise the assessments, the majority of these complaints, the taxing districts were attempting to reduce the assessments. Therefore, we're compelled to change the name of the rules from undervaluation rules to intervenor valuation rules. Pursuant to the Illinois Property Tax Code, any taxing district that has an interest in the assessment that any property is overassessed, underassessed, or exempt may invoke the jurisdiction of the Board of Review to review the assessment and confirm, revise, correct, alter, or modify the assessment as appears to be just. Whenever a taxing body has determined that it intends to file a valuation complaint and the appropriate township filing period has yet to open, the intervenor should serve on both the tax assessee of record and the title holder of record a notice of intent to file an intervenor valuation complaint. Each party must file a brief narrowing and defining the respective issues and any other matters the parties deem appropriate. Each party's brief must contain a demand which must be expressed in both market and assessed value. All notices uh, other than the initial service per Rule 1 of the intervention rules required to be made by parties pursuant to these rules shall be email. Interveners may satisfy filing any documents with this board by sending them via email with a CC to all parties to the chief clerk. Property owners must still file via the portal. Since the initial launch of DAP 6 years ago, the board has created more efficient workflows each year. Please note that the board is constantly innovating and analyzing means to increase the efficiency of DAPs. However, for the 2020 session, at this time, there will be no noticeable improvements or enhancements to DAPs to portal users. That being said, the board did increase certain efficiencies in the PTAG workflow. As you know, the board is committed to defending the county's real estate assessments before the Illinois Property Tax Appeal Board, thereby saving Cook County, the Forest Reserve, and all Cook County taxing bodies millions of dollars annually. As I mentioned earlier in discussing Board Rule 12, due to health and safety concerns for the taxpayers of Cook County, practitioners, and board employees, the board would not conduct in-person hearings until further notice. Non-in-person hearings will be conducted via telephonic and/or video conferencing means. Please note that a request for oral hearing should be done at the time of finalization of the complaint. There's a yes or no box where I request the opportunity to appear for a hearing before the Cook County Board of Review. Based upon the volume and/or demand, the board will schedule hearings at the following times: 8:30, 10:30, 1:03. However, please note it's within the discretion of the board to change these times. With the exception of no in-person hearings due to um, certain health and safety concerns due to the pandemic, there have been no other material or substantial changes to the oral hearing process. However, I'd like to highlight that consistent with past years, the board will email the general hearing dates for that group without assigning specific attorneys to particular dates. Please note that the correspondence will only state the first day that hearings will commence. For attorneys requesting 10 or less oral arguments for any one group of townships, the board would make every effort to schedule those hearings on the same date contained in the initial email notice, and where possible at the same time and call. For attorneys requesting more than 10 hearings per group, the board will likely schedule those cases on consecutive dates to the date contained in the initial mailed notice. Please note that prior to any and all commercial hearings, the respective hearing officer has reviewed any and all evidentiary submissions for that current year as well prior filings. Again, and this is consistent with what we stated with Board Rule 14, the evidence submission deadline is not extended simply by a request for a hearing. Documents for both hearing and desk reviews have the same document submission deadlines. Please note that the maximum number of matters to be heard per call is 10. However, please note that that's subject to change, is within the discretion of the board to change that. Attorneys should limit their arguments to 10 minutes per case. Each call would be limited to 1 hour and 40 minutes. Any attorney or law firm requesting more than 45 cases for oral argument for any particular group must receive approval from the Chief Deputy Commissioner. And this is very important. You must immediately notify Ms. Rodriguez of any scheduling conflicts. After discussing the oral argument procedures for this session, I'd like to transition to recommended best practices, which will include attorney do's and don'ts, um, certain recommendations or suggestions for filing, evidence, and hearings. Let's start with our recommended best practices for filing procedures, and that really starts with the attorney authorization form, and as a reference, we'll refer to Board Rule 2. And I like to emphasize that only the board's original attorney form may be submitted. The form may not be altered in any way from its original format, language, or any other manner. Please note that we posted the 2020 attorney authorization form um, back in December of 2019. Um, Again, and this is something that we highlight each year, is that the form is only valid for the subject tax year and not multiple years. The form must be fully executed by both the attorney and the taxpayer. It's not only signed, but it must be dated. Okay. Now, this is extremely important. Um, you must correctly label the attorney authorization form as the attorney authorization form. Uh, when these complaints are finalized, our DAPS application specifically looks for a document type that's labeled attorney authorization form. If that document type is not located, then your complaint would be subject to a no change 7. And oftentimes on re-review, you see re-review requests is that I submitted everything. However, the issue is that the attorney authorization form was not uploaded and tagged as such during the filing process. So please be mindful that you must um, upload the attorney authorization form as attorney authorization form document type. Earlier in my discussion, in certain revisions to the board rules, I did mention Board Rule 14. Um, we did choose to repeat that simply because of the importance of that rule. Um, uh, and again, um, documents should not be filed after the evidence submission deadline, and it's mandatory that you submit the historical summary form. In the processing of over 250,000 complaints, it's very important that um, that practitioners on the behalf of the taxpayers provide the board with as much information as possible in order to determine the value of the property. Um, it's one of those things that we often say, help us help you. And along those lines, um, the attorney brief or the petition should stand on its own. And to do that, we should have an accurate description of the subject, which will include the property index number, the address of the subject, the size of the subject expressed in square footage, the site size, and the related land to building ratio, the age of the property, and you should clearly disclose whether or not the property is owner occupied or leased. Now, if the property is leased, you should disclose the type of lease. Uh, the analyst shouldn't be left to guess whether or not the lease is net or gross, and then at review, um, there's a request for a copy of the lease or a lease summary. Just disclose that up front. Also, in the assessment history, especially in the units of comparison, uh, for instance, if it's an apartment building, it's units. If it's a strip center, it's square footage, and so forth. Also, you must disclose any and all recent sales. Also, it's very helpful if you disclose any and all blended levels assessments. Now, as a matter of practice, the analyst should look at the PRC to determine whether or not there are different levels of assessments for the subject. Also, you should up front disclose the basis of your requested relief. And any and all income arguments must be supported by mathematical equations and not mere sentences. Not unlike our emphasis on Board Rule 14, Board Rule 27 is equally as important. And again, I just want to emphasize that the review process is that opportunity to submit evidence that was not submitted during the initial review. It's not opportunity to re-argue the same evidence. Um, Included in the grounds for review are newly discovered, obtained, or received evidence, changes in the law, an error in the board's previous application of existing law, evidence provided in response to requests of the board made at hearing, and the correction of a mathematical or calculation error. This is not to argue a difference of opinion. In my early discussion regarding the attorney authorization form, I expressed that it's extremely important that each and every document is properly identified, particularly the attorney authorization form must be separately indexed from every other form. If not, you'll receive a no change 7. All documents should not be indexed, attorney brief or petition or other evidence. And this is merely based on the fact that how our DAPS application works. It's keyword driven and it looks for particular document types and keywords. Consistent with our recommended best practices uh, would be the opportunity at the time finalization of appeal to request administrative no change, where you're just merely exhausting your administrative rights at the board in order to pursue a complaint at either the property tax appeal board or circuit court. Doing that takes the file out of workflow um, uh, and improves efficiencies for both the board and the practitioners. We here at the board strongly encourage the election of the no change 8. If you utilize this option, If you represented the taxpayer in the previous year or the current try, you're presenting the same valuation evidence, be it appraisal that the board has already considered. If you are presenting an income approach, but the subject's actual income, vacancy, and expenses are substantially the same as that of the previously presented to the board, are unable to present evidence at the board level. If you allow your complaints to be released into workflow with merely requests to submit evidence such as appraisal after the evidence submission deadline, the board will be forced to weigh the option of suspending your attorney code. Regarding appraisal evidence, it's highly recommended that you upload the appraisal as one document and label it as an appraisal. If a color version of the appraisal is available, please upload the color version, and also upload the PDF version of the appraisal in its original format instead of a scanned copy. Regarding income and expense data, with rent rolls, our preference is that you submit the rent rolls that maintain in the taxpayer's ordinary course of business and not a summary prepared by the attorneys. We want complete I&E data. 3 years are required. Expenses should exclude interest, real estate taxes, depreciation, amortization. And the I&E data should be up to date at the time of the board filing and not the assessor's filing. And you should fully explain the income expense data, disclose whether the leases are net or gross or other, and what we're just really trying to determine who pays the taxes, and that factors in our I&E valuations whether or not a load is applied. Please note that the Board of Review is fully aware of certain vacancy arguments related to the current global pandemic, and particularly the governor's stay-at-home order, and we are sensitive to these arguments. However, please note that there have been no major revisions to the current Board of Review rules regarding vacancy, and so please review Board Rules 21 and 22. The issue really becomes, just in general, outside of the pandemic-related arguments, what is the value of the property as is? That being said, we still will require recent interior photos dated as of the lien date. Submit documentation attempts to mitigate vacancy, attempts to lease. Owner-occupied properties vacant while listed for sale, not leased. We would give weight, but we're considering any and all evidence, but we would give considerable weight to appraisal evidence in support of the as-is value of the property. Vacancy affidavit should be up to date at the time of the board filing, not the assessor's filing. Property suffering from chronic and long-term vacancy, the board would consider a recent appraisal in support of the as-is value, as well as any and all other evidence of value. One thing that that's new or different in regards to the vacancy affidavit, the taxpayer must attest that he or she are not under investigation for violating the eviction moratorium.
Pursuant to Board Rule 19, the taxpayer must disclose any and all recent sales, should submit the settlement statement, and also disclose relationship between the buyer and seller. Consistent with last year, we would like to reemphasize in the valuation of residential mixed-use properties, less weight would be placed on the income approach. Over the years, we found that the income approach in comparison to sales and uniformity was not as reliable. And it really, the root of it was that oftentimes the income data that was submitted was found to be unreliable in a number of cases. Again, consistent with the 2019 session, little to no weight would be given to market adjustments,
applied in the valuation of condominiums and co-ops. In the very limited instance where a market adjustment is applied, both the petitioner and the board analyst must fully explain in writing um, any and all adjustments in their pleadings and analyst notes. We just discussed the market adjustments for condos and co-ops. So along those lines, if you represent the entire building, file one complaint, not separate complaints. Um, only exception would be is to file a separate complaint for common area parcels. Um, our recommendation is that the pleadings specify the, the relief sought for particular pins. For example, identify the specific pins seeking vacancy relief. We will need the pin percentage of ownership and the OC factor for each individual pin. Also, we would highly recommend that you identify pins with landmark status. Continuing the discussion in regards to condos, we would like to emphasize or highlight that commercial industrial condos are um, condominiums, and there's a recorded declaration. So therefore, um, uh, the practitioners must disclose recent sales within the subject building, including the PIN, the date of sale, percentage of ownership, and the purchase price. If it's leased, we're looking for 3 years of I&E data, the current rent roll, and identify whether or not it's gross or net. The board will consider recent appraisals. Sales history should include all recent sales within the subject. Earlier, I discussed what hearings will look like for the 2020 session. And so we just have certain recommendations for the hearing process. Prior to the hearing review, Board Rule 13, if this is a new client, our recommendation is that you FOIA and review any and all priors. We strongly suggest that you choose your oral arguments wisely, particularly if these are unique circumstances that cannot be fully explained on the face of the pleadings, then that would justify a request for oral. Um, and as I stated earlier, if there's a scheduling conflict, please immediately contact Ms. Rodriguez. During the hearing process, we highly suggest that you explain and disclose any and all changes in circumstances, disclose the type, size, and use of the property. Again, we wish to emphasize that hearings are not an extension of the evidence submission deadline. Do not expect hearing officers to accept new evidence at hearings. We suggest that you disclose any and all pending assessor's recommendations or certificates of correction. Disclose prior PTAB disposal decisions within the tribe. Disclose any and all information regarding omitted assessments. And do not request a hearing simply to attempt to negotiate a pending PTAB. And just in general, know your property. Next, regarding the exemption process, last year we amended the filing periods we reduced it from 4 to 2 installments. And the goal was to have a schedule that allowed the exemption applicant to receive a determination from the Illinois Department of Revenue prior to the issuance of the second installment tax bill. That being said, the first installment will open October 1st, close December 1st. Field checks will be conducted between December 2nd and 23rd. And our goal is to send our recommendations to IDOR no later than February 15th of 2021. The second installment period will open March 1st and close April 1st. Given the board's successful implementation of a digital workflow for the past 6 years, there still remains certain complaints that must be filed at the counter. That being omitted assessments, exemptions, and properties where the basis of the appeal is intervention. Please note that as in past years, the board has explicitly stated that we take very seriously any allegations or claims of the unauthorized practice of law at the board. Please note, practice before the board review is the practice of law. Therefore, non-attorneys or consultants may not practice at the board of review. Attorneys should either be solo practitioners or affiliated with a law firm. Only attorneys may argue cases on behalf of others before the board or submit or present cases on behalf of others to the board. The board of review enlists the assistance of the practicing bar to bring to light any unethical or unauthorized practices of law issues. As we come to the conclusion of the 2020 attorneys meeting, please note that Group 1 would consist of the following townships: Riverside, River Forest, and Oak Park. That concludes the 2020 attorneys meeting. I wish that all are safe and well. And if you have any further questions, please do not hesitate to contact either me or the respective first assistants and chief of staff of the commissioners of the Board of Review. Thank you and enjoy your day.